And now to the latest on Robert Durst. Los Angeles prosecutors are warning that the real estate heir is a danger to witnesses in the latest murder case against him. So they want to videotape those witnesses' testimony in case they pass away before the trial gets underway. So is he a threat? Ken Zimmerman is a National Law Journal contributor, former general counsel. Deborah Blum, a criminal defense attorney, and both join us. Welcome. Kent, let me start with you. He's 73 years old. He's in a wheelchair. He's in jail. He's frail. So what are they afraid of, or is this overreach?
But, Eric, this is a guy who's worth $100 million, accused of multiple murders. He actually admitted in a former allegation that he killed his roommate, chopped him up, and dumped him in Galveston Bay, and he got off. So this is an unpredictable defendant, hard to know what's going to happen. I think in all likelihood, though, the witnesses will testify. Testimony has tentatively been scheduled for February 14, so I think the testimony is likely to go ahead.
So what do you think will happen? I mean, there's going to be a hearing in another week or so. You think that the judge will agree?
Well, I think
go ahead.
Sorry.
Okay, Deborah, go ahead.
I think that if the judge allows this to occur, set the stage for violating Robert Durst's Sixth Amendment's right to confrontation at trial. You could say what you want about him, but he is entitled to a fair trial, which is a fundamental principle of our criminal justice system. These people, there are no known threats to them. We just have their fear. So, you know, the prosecution is saying that Robert Durst is a force to be reckoned with despite his old age, but they're doing things that are making this a public trial before the trial. They released his videotaped confession or interrogation, which is subject to future suppression, and they're now making a public issue of this, so they're poisoning the jury pool.
Well, I mean, the jury hasn't even been seated. I mean, Deborah, what if they do videotape the people and the people survive and they go up on the stand? Wouldn't that testimony, you know, be legitimate and fair, and the jury would be instructed not to pay any attention to, allegedly, that it was videotaped before?
Well, they should have presented these witnesses in the grand jury, which is the proper channel for their testimony, because then that prior testimony would be sworn to in an official setting, and it would be subject to cross-examination based on prior inconsistent statements. This is a very unorthodox approach.
Well, I mean, Ken, there is a point. I mean, that huge documentary. Everyone knows about Morris Black, his former roommate, whose head was found, or I guess the head wasn't found. His body was decapitated. You've got Susan Berman, his very close friend, and the allegations or speculation are that he may have told Susan about the disappearance of his ex-wife many years ago. Susan, the Los Angeles writer, very well known. I mean, it's all out there anyway, so how do you get a jury to try to, you know, give Robert Durst a fair trial, especially when you have this?
You know, I think you're right, Eric. There's evidence mounting, kind of coming at Durst from all sides. Also, as you know, the interview was released that he gave the LA police shortly after being captured in New Orleans. And in that interview, he admitted he was on the run from the law. He admitted he doesn't think he's a very good guy. He admitted that he thought he's not a very good fugitive. And I think he's going to have a problem, whatever happens next. I think it's very unlikely he's ever going to see the light of day as a free man again.
Is what he told is that actually does the jury would that be allowed in, you know, in his trial?
Well,
I think go ahead, Ken.
Yeah, I think likely it's going to be admissible. He was read his Miranda rights by an LAPD detective before he gave the statement. He was told, you know, what you say could be used against you in court. He said he understood. And then he went ahead and gave the interview. And typically after a defendant is Mirandized when he's in custody, usually what he says then can come in. So I expect it likely to come in before the jury when we get to trial.
And Deborah, how will that impact a potential jury?
Well, I think that the defense will have to do their job and argue that he said it while he was under the influence of drugs, which has been previously mentioned. And also, I want to focus on the fact that they have a witness who's 85 years old, and the prosecution is trying to create a hearsay dying declaration type of exception where they're trying to get in testimony of witnesses which will not be subject to cross-examination.
And that's Dr. Albert Cooperman, who's 85 years old. Final thought, very quickly. What do you think is going to happen, Deborah?
I think that the witnesses will testify, but I do agree with Kent that most likely the videotape interrogation will come in.
And Kent?
Yeah, I agree with that. Here's a little bit of a curveball, Eric. I actually think they're setting up a possibility where they're going to say he's not fit to stand trial. You see it coming with the pink wheelchair, the neck brace. Durst says he's goo-goo gaga in his words, in his statements, and I think the evidence in, and they might just say he can't stand trial. He's not fit.
That's fascinating. Yeah, that could make potential sense. Kent and Deborah, thank you for your insight. We'll see what happens next week.
Happy holidays.